Welcome to The Last Track, where we help people showcase the last track of their life story in their final wishes. I am your host, Brian Norris, the co-owner of Bateman Funeral Home in Newport, Oregon. Just like a song can bring you back to a day, a time, and a memory, so too can a well-planned service. Well, good afternoon. We have a special broadcast today that's talking about estate planning. My name is Brian, and I'm the managing partner at Bateman Funeral Homes. And I have a guest today. And if you've followed us at all, you've heard from him once before, Brian Haggerty. And he is a lawyer that's focusing his practice on wills and estate planning and trusts and elder law. He earned his Juris Doctor degree, and has a certificate in federal tax law from Northwestern School of Law of Lewis and Clark College, and he earned that back in 1997. I know, can you believe it's been that long?
So last century.
Definitely. He passed the bar the following year, and he currently serves as a captain as a firefighter, as a fireman. I guess I'm saying it's totally wrong, but he's a captain here in the Newport Fire Department, as well as on the board of the community of the Hospital Foundation. And he also practices here in Newport. And so I'm pretty much butchered his introduction, and I'm sorry, Brian. I'm going to actually turn it over to you so that you might be able to say a few more things about yourself here. Get to brag about yourself.
Well, I've been here in Newport doing estate planning, probate, trust administration for about 23 years. During most of that time, I have volunteered with the Newport Fire Department, and I'm a captain because I've been around so long they couldn't think of anything else to do with me. And an emergency.
You go and take the hydrant, huh?
Yeah. Yeah, and actually that's a big thing to know how to do.
Yeah.
But yeah, and other than that, I guess there's very little that's interesting in my life. I'm married to my lovely wife, Linda, and I have 2 children, and she has 3, and we now have 4 grandchildren.
That's exciting, isn't it?
Yeah, it's amazing.
Every now and then, too, you might hear Brian performing at the PAC.
Maybe if that ever becomes a thing again.
If it ever happens again, right?
Yeah.
Well, we're going to talk a little bit about estate planning. And you might wonder, well, why is a funeral home talking about estate planning? Because normally, people come into us, and obviously we've taken care of somebody that has passed away. But it's one of those things that I think is really critical, because, Brian, I can't tell you how many times I'm sitting in front of somebody and they look completely lost. And as soon as I say something about the legal next of kin, their eyes glaze over and they're like, well, isn't that me? And I'm looking at them, and they may or may not be married to the person, or they could be a cousin or a stepchild. And it's kind of crazy.
Yeah.
So let's talk a little bit about estate planning. And I think maybe what we'll do is kind of approach it from an angle, because another thing that I get from families is, well, my mom's estate is hardly anything. So isn't just estate planning for the wealthy? And I'll leave that question with you.
Well, everybody has something. I mean, unless you've taken a vow of poverty and you're living in a monastery, everybody has something, and everybody has things that are important to them and important to their kids and the people in their family who will inherit.
Right.
So everybody's got an estate, and everybody's got an estate plan. Some people's estate plan is whatever the Oregon legislature has chosen to codify in the Oregon Revised Statutes,
Right.
which is sad when, it's fundamental to our system of law that you have opportunities to direct where your property will go when you pass away.
Right.
And even if it's only the dinner table that everybody's had Thanksgiving dinner on for the last 10 years, well, that may be something worth making a plan for.
Right. Yeah, because it might not have extreme dollar value, but the sentimental value is incredible sometimes.
Yes.
And that, I think, sometimes when we get families that come in here and they're completely in lockstep and they all know exactly what's going to happen. And then we get the families in here, and I've actually sat with some families and they start fighting in front of me about, well, no, I get mom's earrings. Well, the earrings, honestly, I'm looking at those and I'm thinking, $200.
Yeah.
And you're fighting over earrings.
Yeah.
But yet it's that sentimental value, and it can really, really drive some tempers at times.
Yes.
Emotions that are just, and I think I want to mention that as well. I think maybe for me, in my mind, and correct me if I'm wrong, but I think estate planning should be done hopefully well before there's going to be any emotional decisions that have to be made. Am I correct?
Yes, although it can be emotional to see people decide about how to draft the will in terms of who gets what. I mean, that can be an emotional decision too. But
sure.
But yes, it should be done well in advance.
Yeah.
Too often we see people who are trying to do their planning right at the end because they've gotten that terrible news from the hospital.
Get your estate in order.
You're not in the clearest frame of mind at that point, for starters.
Yeah.
And with the railroad train charging down on you, it might not be the best time to be making those decisions.
Right. Yeah, and you're right. That's that when you get that news of you probably have 6 months, it's probably time to get your affairs in order from the doctor. That can be difficult. And then when you have children on either side of you, or maybe you have some stepchildren that you definitely feel that they are your children, no matter
right,
that type of thing. Adopted children, and then you have the blended families a lot of times where there's maybe you essentially raised the neighbor's kids, and they're as much as yours as anybody else, and you want to include them. But in the state of Oregon's plan, it would not include them, would it?
Right. No, it wouldn't.
Yeah.
Yes. And so it's since you have that opportunity to express your wishes and to set out a plan, you really ought to take it. You, as much as anybody, knows that nobody gets out of here alive. So it's coming, and the only sensible thing to do is to plan for it.
Yeah. So we've talked a little bit about the estate planning. Can a will or a trust, if you write up a will, or because I hear that a lot, well, in my will or in the will, it says XYZ, or in the trust, can that be avoided if you do like a joint ownership of everything?
It can, but that's the hardest estate plan to maintain.
Okay.
The lovely thing about a will is you create a will, and when it passes away, it will govern the disposition of every single thing you own.
Okay.
Period. And so you can put in one document all of your thoughts and all of your plan. It's all right there. And you take that document out, you read it through, that's what the plan is.
Okay.
For most people, they will have a combination of a will and some number of beneficiary designations, especially where you have retirement plans like IRAs, 401ks, 403bs. those have to have individual beneficiaries named. You get a very bad tax result if that kind of retirement plan goes into your probate estate.
Okay.
So for most people, there's a combination of beneficiary designations and the will. And that is about all the complication you want to sort out. You want to make sure that that the beneficiary designations work with what you've said in your will so that it all works the way you think it is.
Okay.
The difficulty with people creating joint ownership is that it's joint ownership. You don't own your stuff anymore. You've given away some of that ownership to somebody else. So now you don't have control. If people always like to talk in terms of putting the kids' names on the house.
Right. I was just going to ask you that.
That's not what you're doing. What you're doing is you are transferring ownership of a portion of that house to your kids. Now you don't own your house anymore.
Right.
If you want to sell your house, you have to go to your kids, hat in hand. Can we sell the house? In some families, that will work. In other families, it isn't. It's going to run into some difficulty.
Yeah, especially if you put, let's say you have 3 children, and so you put all 3 children on it, and now, that person passes away, and you have 3 children that own a house.
Right.
And now they're trying to.
That's absolutely an almost certain way to blow your family up.
Yeah.
Because those 3 kids are not going to agree on what to do with the house. At least one of them can't afford that house.
Right.
So at least one of them is not going to be paying his or her share of property taxes and home insurance and things like that. That'll get the other 2 angry.
Right.
The other part of joint ownership that is generally not understood is that when you name someone as a joint owner of a bank account, under Oregon law, when you pass away, that joint owner owns the account.
The entire account, right?
The entire account. So your will might say all to my 3 kids equally, but this one bank account now is owned by one of those 3 kids. A goodly number of people in that situation will say, well, that's not what mom wanted. She wanted to split it equally, and so we split it equally.
Sure.
But it's not unheard of to have that child who goes, oh, really? That's mine? Fine. That's what I'm going to do then. I'm keeping it.
So is it better than to put them on just as a signer rather than an owner?
Well, it's usually there's no way to just be a signer.
Okay.
Someone else can be named as an agent under a power of attorney, and you give the power of attorney to the bank, and that works. But if there's anybody else's name on the account, tends to be in terms of joint ownership.
Okay.
And there you have it.
That's good to know.
Yeah. And then just again, going back to simplicity, the simple way to do this is to own everything that you own and make a will. That's the most straightforward approach. If you start complicating things with joint ownership and with beneficiary designations, it just becomes very difficult to keep everything sorted out.
Right. Okay. So I guess that kind of leads to the question, and we've touched on it briefly here, but if you don't have a will or a trust, what happens? And is there any dollar figures to be aware of?
What happens comes down to what the Oregon legislature has established for people who are intestate, meaning they don't have a will.
It doesn't mean that they don't have money. It's not like indigent is intestate.
Right. It's just intestate, no will. And the Oregon statutes follow pretty closely what most people choose to do, but they can't handle any sort of special circumstances. You mentioned the stepkids,
right?
For example. second marriage, two people get married, each of them has children. Most of those married couples will hold everything jointly. So when one of them passes away, the other now owns everything.
Right.
If that person doesn't have a will, when that surviving spouse passes away, everything goes to that spouse's children.
Oh.
And the children of the first spouse to die are just done.
They just
get
don't
nothing.
They're not even recognized at all in that.
Right. So because the statutes say, well, we take care of the spouse and we take care of the children.
Right.
But the children means the natural children of this person who's deceased.
Right. So unless they've legally adopted those children, then that can be rough.
Yeah. And actually fairly common.
Yeah. Well, we see it here. So
yeah. And if it's already, when you think about it, you're involved within hours or days after someone has passed away.
Right.
If you're already seeing friction in the family, carry that out 6 months and imagine how frictiony it's gotten at that point.
Yeah, because how long does it take for an estate to go through probate if there's not a will or that type of thing?
It's essentially, whether there is or is not a will, the probate process is essentially the same.
Okay.
And it can be done in as little as 6 months. It can't really be done.
Little.
Right.
As little as 6 months.
There's a mandatory 4-month waiting period during which you have to identify claimants, creditors who might have some claim against the estate.
All right. Okay.
In most estates, that's 4 months of sit back and wait.
Yeah.
And nothing in particular is going on. So you have a rush of work in the first month and a rush of work in the last month. And those 4 months just sort of chug along.
Right. As you're waiting for, the mail to arrive and you go, oh, I didn't know mom had this credit card.
Exactly.
Oh, wait a minute. What happened to this card? And yeah.
Yeah. Now it's important to note that nothing is frozen during that 6 months. The person who is either the personal representative, because there's a will, or the administrator, if there is no will, that person has complete control, can sell real property, can change investment decisions. That person has control over all the property of the estate.
Right.
The only thing he can't do is pay any of it out to the heirs or the devisees.
Yeah, because they're still waiting on that, but they can still, if they're making investments or buying and selling stock or that type of thing, they can do that, but it has to be for the good of the family, right?
Right, exactly.
Right.
It's for the estate.
Okay. Well, we talked a little bit about, in fact, actually, I think just before we went live, we were talking about going and if you can go to get those generic wills and that type of thing. And maybe we weren't talking about that, but there's these websites out there that you see where you can go and then you click down and it says Oregon, and then you fill out and you can hit print, and then for $5.99, you have and I'm talking $5.99. Right. You maybe get a will or something. Are those? I'm sure you ran into those.
The lawyers who practice probate litigation, who in other words sue people over estates,
right.
They love those things.
They love those forms.
They love those things. I've been doing this for 23 years, and literally I learn something new most weeks. Certainly something new every month. Life is complicated, and when a life comes to a sudden stop, there's a lot of complication to work through. Right. And you can't ignore it. You can't just put your head in the sand and pretend it doesn't exist. You have to work through those things. So a well-crafted will, where someone has looked ahead and anticipated this asset may be a problem. We need to provide for this. This devizee, this heir might be a problem. We have to provide for that person.
Right.
That kind of planning based on experience with previous probates is just invaluable. The other thing about the internet forms is they're on the internet. They are primarily driven by those states that have the most population. They're driven by California and New York, Texas and Florida. So those kinds of, they try to personalize it for Oregon, but they're really looking at the revenue streams coming out of California and coming out of New York. So you often see those that are, they're not completely wrong under Oregon law, but they're weird. And they may just take a different focus on things. The final thing I'd say about the internet form is that there are certain customs in estate planning. And just for an example, we customarily separate out tangible personal property, that is your household stuff, the silver and grandma's dishes and things like that, as a separate category. Because usually you want people who have some kind of personal connection to those things to inherit those things. That's normally going to be the surviving children. And there may be one particular child who should inherit this particular thing. So we call the tangible personal property out, and then everything else is in a category that's just called the residue, which sounds like what's on the bottom of your coffee cup when you're done. But it's usually most of the value of the estate. And when people don't understand that basic kind of split, they tend to fill out the internet form wrong. They haven't understood that this paragraph is just referring to that tangible stuff, the stuff you can pick up. And they'll make provisions for bank accounts and things like that. And it ends up being really, really badly skewed. Final comment for anybody doing their own will online: you don't need to put anybody's social security number in the will.
Heck. Yeah.
The will is going to become public. It's going to be included in a public court file. If you've littered the whole thing with people's social security numbers, you've just given away. I mean, you may as well sell those social security numbers on the dark web and at least make some money out of it. Don't just give them away.
So don't do that, huh?
Well, it's like that old commercial, for the plumber. You can pay me now or pay me later.
There you go.
If you're having to pay a litigator to clean up multiple mistakes, that's going to be a way more expensive than paying somebody to do it right in the first place.
Okay. So if you're talking to somebody and they're saying, "Hey, I'm thinking about doing an estate planning. How do I get started?" Can you address maybe the younger family that might not have as much, and then the older family? Where do you start? Well, I mean, what do you do?
You basically need to know who the players are. Who are we going to be providing for in this estate plan? And with most older couples, you can usually put together a quick family tree that goes up to their parents and down to their grandkids.
Right.
So now we know where all the players are. And we could kind of figure out, well, this is how this would naturally flow if you didn't have any plan in place. And then you can start picking out, this beneficiary has special needs and we need to do something particular for that person. The other thing that you need to know is what is it that you own? It took me a long time to figure out that when people talk about my home, they may not actually own it.
Oh,
You have to look at the county records and figure out who really owns this home.
right.
Frequently, a widow or widower has not gotten around to removing the deceased spouse's name from the county records. So you still have, we're doing a probate for mom, and first we have to sort out dad's ownership interest in the home. So you need to know what you own, and not down to the nickel, but you need to take a good look at, well, if I total up everything that I own, how much is that? Not only so that you can do a better job of dividing it up among the people that you want to benefit, but also because you have to keep one eye on taxes. Oregon still has an estate tax,
Right.
and it's got $1 million exemption. So if your estate, sorry,
the first million exempt.
Right. And after that, it only runs between 10 and 16%. So it's not like the federal estate tax where they're running from 40 to 60%.
Right.
So Oregon estate tax in some cases is not even really worth avoiding. But you should at least, that's part of the keys to a plan, is you don't always have to handle every issue that comes up, but you should look at that issue and understand that issue and decide, okay, I'm not going to do anything about that.
Right. So can I interrupt you for just a second? Because, when you say $1 million, that sounds like a lot, but I was, if you're thinking about the fact, let's say maybe you have a home, and, a home today can be $400,000, $500,000, $600,000.
Right.
And then, so it's not the fact that you don't have $1 million in a bank account. It's if you've got 2 cars and you've got a home, let's say maybe you have a couple $100,000 in the bank, all of a sudden that might add up to $1 million.
Right. Yeah, you're nudging right up there.
And you know that person's a millionaire, but their cash wasn't $1 million, but the home, which people maybe somebody bought this home for $100,000 40 years ago, but it's sitting overlooking the ocean and it's on 1.5 acres, and now it's worth just the property. The property might even be worth more than the home.
Yeah. So it's and that's why you need to take a careful look and make yourself a list of everything you own with what you think the values are. You incidentally want to keep that list very, very carefully protected.
Don't put that on Facebook.
Exactly. Please don't post that on Facebook.
Yeah.
But you just need to go through and write yourself a list of, this is everything I own. And most people will find out that it's a lot more than what they were expecting.
Yeah. So after let's say you've done an estate plan, and, I did one 25 years ago, and now all my kids are out off on their own. I have grandchildren. It's just me and my wife. And well, I have a will, but it was written back when, I was worried about the kids getting raised if we died. How often should you go back and take a look at your estate plan?
You should look at it every 3 years.
3 years.
And it may be that, in 3 years, not a lot has changed and there isn't a need to make any changes. But there are also, you can keep one eye on changes that are going on in society and in the law. One of the things that I had to start adding to wills 4 years ago or so was a provision for digital assets.
Oh,
Because there are some things that people now own which have no real reality. We've got this Facebook Live recording, which is of
right.
course an extremely valuable asset.
Absolutely.
But it's out there.
Yeah.
And when you pass away, now the various social media companies have been moving to correct some of this, but at least early on, when somebody passed away, they would just shut down the account. Gone.
Right.
And it may be actually illegal to access somebody's email after they've passed away. So now my wills all have this term that says my personal representative has specific authority to access my email and
Right.
access my online banking and my online brokerage accounts.
Right.
And that's just a huge convenience. If anybody is doing things online at all, it's really, really helpful to be able to just log in, get the information that you need.
Right. That's another thing too, is you might want to keep your passwords in a safe place, but make sure it's in a safe place that someone knows about it.
Right.
It's not sitting in the middle of the Bible, somewhere that no one will find it. It's
right.
Make sure you tell somebody where you put that.
As long as you tell somebody. And for the kids out there, safe means you took a pen and you wrote it on a piece of paper, and then you fold that up and you put it in that's safe, because that I guarantee cannot be hacked.
Yeah.
Well, just about anything that's online, somebody's going to figure out a way to get to it.
Well, this thing right here, I can't tell you how many times when we've picked up somebody and they have a phone and you have to use a thumb to access it.
Right.
And we have members going, "Can we please see Dad so we can get into his phone?" So yeah, those are things to think about.
Yeah. And actually the answer is no. because dad cannot give meaningful consent to you getting into his phone.
Yeah.
So no, sorry. Unless you can show me that term in the will that says my personal representative can get the funeral home to put my thumb on my phone and let me in.
And it's interesting. And those are things that I think that people, if they're just going to an online thing and pulling it down, that's the stuff that they're missing. That information.
Yeah.
Well, the last thing I'm going to ask you, and we thank you very much for the time that you've shared with us, but one of the last things I'm going to ask you is now that I've kind of thought about some things and I'm going to pull it together and I'm going to start making a pile. When I come to visit with you to do an estate plan, what are some of the things that you want to see, what I should bring to you? Right.
So we'll want the family tree. We want the list of assets. The single most important thing that people usually haven't thought through is who will manage my estate. Okay. Who will be either my personal representative or my successor trustee if you're going to use a revocable trust. That person has to be absolutely honest and businesslike. You essentially need Sir Galahad because he's absolutely honest and he gets things done.
Yeah.
And that person has to be able to follow your plan, right. Not his plan, but your plan, the one that's written down. And those three things,
or succumb to if you have siblings saying, I need more money, and that kind of thing. They just need to be able to follow that plan.
To stick with the plan and say no if no is required, and not to substitute his own thinking for what should be going on.
Got it.
I've always well, let's say you got the guy who's always hated his brother, and maybe it hurts to write that check at the end of the probate, but he's gotta swallow it and make that happen.
Yeah. All right. Well, if you had one piece of advice to offer as we close this Facebook Live, what would that be?
It would be make a plan and stick to your plan. You want to take those affirmative steps to put something in place so that when you pass away, this is what's going to happen. It's going to have to be written because you will not be available to shepherd this plan through. So it has to be written down, and nothing that you said during your lifetime is going to help. We get this all the time. The folks who say, well, Mom said that I could have the silver. Well, she didn't say that. She may have said that, but she didn't write that.
Yeah, and if it isn't written, it didn't happen.
And we can't verify with her that that's what she wanted. So what she wrote that's all she wrote.
Yeah. All righty. Well, if the audience, anybody listening today, wanted to find out more about you and about the services you offer, where should they go?
Well, they can always look at Catch the Wave, which is the community college's, I think it's a quarterly publication regarding what's coming up this term. And I teach a class. It's 3 2-hour sessions. And that's all designed to fill in all of these questions about how do I become an active participant in making an estate plan for myself.
Yeah. And I know you have a class this October. It's full. I don't know if they have a wait list or anything, but you do that each quarter. So like in October, you'll do another one in January of 2022, right?
Right. Yeah. January or February.
Okay.
They do have a wait list, and so people could call and get in for this one probably.
Okay. Well, that's good. Well, people, if you're having any questions, I would encourage you to take a look at that and get your assets together. It's
right.
I mean, it's just I can't tell you. It's the families that come in and everything's been pre-planned and they have an estate plan and they know where they're going after they leave me. It's just so much more calm. The stress is there. Yes. Everybody knows what's going to happen. They've all talked through it, or if they haven't talked through it, there's at least one person that has with that person that's passed away, and they can say, "This is what's going on. This is what Mom wanted, and it's right here, and this is what we're going to do." And it's just so much easier. So,
and that's going to be a family that's going to be together and still sharing Thanksgiving dinners, for many years into the future.
Yes, indeed. Well, thank you very much, Brian. It's been great having you on. I appreciate you taking your time out of your day to visit with us.